Good morning and welcome to the 7th meeting of the Health, Social Care and Sport Committee in 2025. I've received apologies for this meeting from David Torrance, and Jackie Dunbar is joining us as a substitute. The first item on our agenda is to decide whether to take item 5 in private. Are members agreed? Thank you. Our second item today is continued consideration of the National Care Service Scotland Bill at Stage 2, and I welcome the Minister for Social Care, Mental Wellbeing and Sport. I will briefly explain the procedure we'll be following during today's proceedings for anyone watching. The members should have with them a copy of the bill, the marshalled list and groupings. These documents are available on the bill website on the Scottish Parliament's website for anyone observing. I will call each amendment individually in the order of the marshalled list. The member who lodged the amendment should either move it or say not moved when it's called. If that member does not move it, any other member present may do so. The groupings of amendments sets out the amendments in the order in which they'll be debated. There will be one debate on each group of amendments. In each debate, I will call the member who lodged the first amendment in the group to speak to and to move that amendment and to speak to all the other amendments in the group. I will then call other members with amendments in the group to speak to but not move their amendments and to speak to other amendments in the group if they wish. I will then call any other members who wish to speak in the debate. Members wishing to speak should indicate that by catching mine or the clerk's attention. I will then call the Minister if she's not already spoken in the debate. Finally, I will call the member who moved the first amendment in the group to wind up and to indicate whether he or she wishes to press the amendment or to withdraw it. If the amendment is pressed, I will put the question on the amendment. If a member wishes to withdraw an amendment after it has been moved and debated, I will ask whether any member present objects. If there is an objection, I'll immediately put the question on the amendment. Later amendments in a group are not debated again when they are reached. If they are moved, I will put the question on them straight away. If there is a division, only committee members are entitled to vote. Voting is by a show of hands. It is important that members keep their hands raised clearly until the clerk has recorded their names. If there is a tie, I must exercise a casting vote. In normal circumstances, the committee is also required to formally consider and agree each section of the bill. However, in this case, since a number of amendments seek to leave out entire sections of the bill, a separate decision on those sections will not be required. Where a separate decision is needed, I will put the question at the appropriate point. And I call Amendment 73 in the name of Gillian Mackay, grouped with amendments as shown in the groupings. Gillian Mackay to move Amendment 73 and to speak to all amendments in the group.
Thanks, Convener. Most of my amendments in this group relate to the definition of and the quote and what's in the bill around sufficient breaks from providing care for the cared for person. And there have been significant concerns about this definition from carers' organisations. I'm sure it wasn't meant in this way, but many carers don't actually want a break from the cared for person. They want a break from the act of caring itself, and quite often would probably like to have a break alongside that cared for person. It's particularly true for parents who are caring for their children, and I think this definition should be left out and potentially something else looked at being put back in. My amendment 131 and 88 are looking to define that sufficient breaks, and I'm aware Jackie Bailey has an amendment as well. Amendment 131 in particular is looking around a reasonable limitation of how long people are caring for, and a recognition of the carer's right to rest, which again was very important to many of those carers. On Jackie Bailey's amendment, I don't think 2 weeks may be enough for some people, and I think that does have to be done on an individual basis. And while I appreciate Jackie Bailey's intention for wanting to set out some form of at least baseline of limit, I worry that it might be seen as a ceiling rather than that floor. Thanks, Convener.
Can you move the amendment, Ms Mackay?
Moved.
Thank you. Jackie Bailey to speak to Amendment 132 and other amendments in the group.
Thank you very much, Convener. I think we know it's estimated that there are about 700 to 800,000 unpaid carers living in Scotland. And Scotland's care service is struggling. Many are unable to access the support they're entitled to, and as a consequence of that, unpaid carers take on a greater role in supporting the needs of loved ones. I am concerned about the lack of detail. I share Gillian Mackay's concerns about the lack of detail around right to breaks in the bill as introduced. So I've lodged Amendment 132 that calls for a clear definition of sufficient breaks, and I've suggested that carers should receive a minimum, not a ceiling, but a minimum of 2 weeks break. However, I think the committee and the Minister will recognise that this is a probing amendment. I would be delighted if the Minister went further, but I think it would be helpful to establish what would be deemed sufficient in terms of breaks. Thank you, Convener.
Thank you. Minister.
Thank you, Convener. I welcome the intention behind Gillian Mackay's amendments 73 to 80 and 83 to 85 to ensure that the new rights to breaks can include provision of breaks taken together with a cared for person. While I consider that the existing bill provisions do not prevent short breaks being taken with the carer and cared for person together, I'll absolutely support these amendments to make sure that's absolutely clear. I am, however, concerned by one potential consequence of the definition of breaks proposed by Amendment 85, which is that it could allow local authorities to give effect to the right by providing a carer with breaks unrelated to their caring role. I'm sure that was not the intention, so I'd like to work with Gillian Mackay, Head of Stage 3, to develop a definition that doesn't risk undermining the right that we are all trying to confer. I'm also happy to support Amendment 81 from Gillian Mackay, which would turn the regulation-making power to make further provisions about breaks into a duty to make regulations. It was always the intention to make regulations, so turning that may into a must does no harm. Gillian Mackay's Amendment 82 is, I think, intended as a minor drafting amendment to add the word also in consequence of Amendment 81. I do not think it's necessary or helpful as a consequential change and therefore do not support it. If Gillian Mackay thinks it's more than a consequential change, however, I'd be happy to discuss with her about what she means it to do and how that could be more clearly expressed. I do have a number of concerns about Gillian Mackay's Amendment 131 and Jackie Bailey's Amendment 132, which set rules about how those regulations should define sufficient breaks. In both amendments, there are aspects of the wording that doesn't work. For example, Amendment 131 talks about working hours, which is an employment law concept. That's not how we would draft regulations related to unpaid care. I should also emphasise that I consider a provision that requires recognition of Article 24 as drafted raises questions of legislative competence, given the reservation of international relations under the Scotland Act 1998. Amendment 132 talks about a minimum entitlement of a 2-week break. However, it's unclear what is to constitute a break in that context and whether it means 2 weeks consecutively or cumulatively or over what period, a month, a year, a lifetime. Beyond the wording, some of the principles behind these amendments are inconsistent with feedback from carers in our previous consultation. Overwhelmingly, responses favoured personalisation over standardised entitlements. There is also the concern that by setting rules about what regulations defining sufficient breaks have to say, these amendments would preempt the intended consultative process. By imposing rules about what regulations have to say now, we might end up preventing the regulations setting out a definition in the terms that carers, delivery partners and other consultees want to see. So while I can't support either Amendment 131 or 132, I would be very, very happy to discuss what might be possible with Gillian Mackay and Jackie Bailey ahead of Stage 3, so that we ensure that we end up with a definition of sufficient breaks in regulations that's workable and reflects the views expressed through the intended consultative process and which can be adapted in future if required. Gillian Mackay's Amendment 133 is consequential on her Amendment 131, and as I don't support Amendment 131, likewise I ask members not to support Amendment 133. Finally, in this group, I am pleased to support Gillian Mackay's Amendment 88, which would extend the range of information that a short break service statement has to contain, and so increase transparency around the availability of different types of short break services and what local authorities are doing to meet demand. I think there are some ambiguities in the drafting of Amendment 88 which I'd like to resolve at stage 3, and I'll be pleased to work with Gillian Mackay to do that.
Thank you, Minister. Gillian Mackay to wind up and press or withdraw Amendment 73.
Thanks, Convener. I don't have anything else to add, so I'll press Amendment 73.
The question is that Amendment 73 be agreed to. Are we all agreed?
Yes.
I call Amendments 74, 75, 76, 77, 78, 79 and 80, all in the name of Gillian Mackay and all previously debated with Amendment 73. I invite Gillian Mackay to move Amendments 74 to 80 en bloc. Does any member object to a single question being put on Amendments 74 to 80? No. The question is that... Can you move the amendments en bloc, Ms Mackay?
Moved en bloc.
Thank you. The question is that Amendments 74 to 80 are agreed. Are we all agreed? Yes. I call Amendment 81 in the name of Gillian Mackay, already debated with Amendment 73. Gillian Mackay to move or not move?
Moved.
The question is that Amendment 81 be agreed to. Are we all agreed?
Yes.
I call Amendment 131 in the name of Gillian Mackay, already debated with Amendment 73. Gillian Mackay to move or not move?
Not moved.
Okay. I call Amendment 132 in the name of Jackie Bailey, already debated with Amendment 73. Jackie Bailey to move or not move?
Not moved on the basis of further discussion with the Minister.
I call on Amendment 82 in the name of Gillian Mackay, already debated with Amendment 73. Gillian Mackay to move or not move?
Not moved.
I call on Amendment 133 in the name of Gillian Mackay, already debated with Amendment 73. Gillian Mackay to move or not move?
Not moved.
I call on Amendment 83 in the name of Gillian Mackay, already debated with Amendment 73. Gillian Mackay to move or not move?
Moved.
The question is that Amendment 83 be agreed to. Are we all agreed?
Yes.
Excuse me. I call Amendment 84 in the name of Gillian Mackay, already debated with Amendment 73. Gillian Mackay to move or not move?
Moved.
The question is that Amendment 84 be agreed to. Are we all agreed? Yes. I call Amendment 85 in the name of Gillian Mackay, already debated with Amendment 73. Gillian Mackay to move or not move?
Moved.
The question is that Amendment 85 be agreed to. Are we all agreed? I call Amendment 134 in the name of Brian Whittle, already debated with Amendment 123. Brian Whittle to move or not move?
On the basis of last week's discussion and debate, I will not move.
So the question is that Section 38 be agreed to. Are we all agreed? I call Amendment 86 in the name of Gillian Mackay, grouped with Amendment 87. Gillian Mackay to move Amendment 86 and to speak to both amendments in the group.
Moved Amendment 86, Convener. These amendments seek to strengthen support for carers by ensuring clear timescales for the preparation of adult carer support plans and young carer statements under the Carers Scotland Act 2016. Currently, there are no statutory deadlines for local authorities to produce these plans, leaving carers without the support they need. Unpaid carers have long reported frustration with delays in accessing assessments and support. Without clear deadlines, carers can be left waiting indefinitely, undermining their ability to balance caring responsibilities with their own well-being. The introduction of statutory timescales will provide much needed accountability and ensure that carers receive timely recognition and assistance. Additionally, these amendments repeal Sections 7 and 13 of the Act, which currently allow local authorities to decide whether to prepare a plan or statement if a carer's identified needs do not meet eligibility criteria. Removing these provisions will ensure that all carers, regardless of eligibility, receive a formal assessment, reinforcing their right to support and acknowledging the vital role that carers play in our system.
Thank you, Ms Mackay. Minister?
Thank you. I support Amendments 86 and 87 brought forward by Gillian Mackay to ensure that carers can access support in a reasonable timescale, including support under the new right to breaks. Until a carer has an adult carer support plan or a young carer statement, they're unable to access statutory carer support, including short break support. I acknowledge how essential it is that carers are supported to take care of their own health and well-being while maintaining their caring role. Statutory timescales would support consistency between areas and help promote early intervention. However, I am well aware of pressures on local carer services. In setting timescales, therefore, it will be important to engage with carers and services to balance the needs for such plans to be prepared in a reasonable time while not adding to the pressures on services and allowing them to prioritise carers in urgent need. With that in mind, I intend to retain the accelerated timescales currently set out in regulations for carers looking after someone with a terminal illness. I would urge members to support Gillian Mackay's amendments 86 and 87.
Gillian Mackay to wind up, press or withdraw Amendment 86.
So I thank the Minister for her support of these and press Amendment 86.
The question is that Amendment 86 be agreed to. Are we all agreed? I call Amendment 87 in the name of Gillian Mackay, already debated with Amendment 86. Gillian Mackay, to move or not move?
Move.
The question is that Amendment 87 be agreed to. Are we all agreed?
Yes.
I call Amendment 135 in the name of Brian Whittle, already debated with Amendment 123. Brian Whittle, to move or not move?
Not moved.
The question is that Section 39 be agreed to. Are we all agreed? I call Amendment 88 in the name of Gillian Mackay, already debated with Amendment 73. Gillian Mackay, to move or not move?
Move.
The question is that Amendment 88 be agreed to. Are we all agreed?
Yes.
No. No. The committee is not agreed. There will be a division. Those members in favour of the amendment, can they please indicate? Those against? Any abstentions? The result of the division on Amendment 88 is 8 members for, 2 against. There were no abstentions, therefore the amendment is agreed to. The question is that Section 39 be agreed to. Are we all agreed? I call Amendment 88 in the name. Sorry.
We've done that.
Okay. So we're on to Amendment 50? Yes, okay. I call Amendment 50 in the name of the Minister, grouped with amendments as shown in the groupings. Minister, to move Amendment 50 and to speak to all amendments in the group.
Seeing and spending time with loved ones is a fundamental human need and is central to the provisions relating to Anne's Law within the bill. I, along with the First Minister, have been profoundly impacted by what relatives and others have told us about their experiences during the pandemic. We have listened very carefully to those who have campaigned for Anne's Law, and I've brought forward my Amendment 50, which will ensure that people living in adult care homes can always connect with the people who are important to them, both in and out of the home, unless there are exceptional circumstances. And even when there are exceptional circumstances, it will require that some types of visit will always be supported, namely in end-of-life situations and where the suspension of visiting would cause serious harm to the residents' of health or well-being, and that harm would outweigh other risks. Some family and friends are not simply visitors. They are essential care supporters, an integral part of the care team for their loved ones. So my Amendment 50 gives formal recognition to their role in providing care, support and companionship as called for by Care Home Relatives Scotland. It provides for there to be identified for every care home resident at least one person who is an essential care supporter, and the amendment provides a legal presumption that suspending visits from that person will always cause serious harm to their loved one's health and well-being. The approach builds on existing practice, which is reflected in the 2 current health and social care standards and in guidance. I am deeply grateful to the members of Care Home Relatives Scotland and others who have helped us in developing this approach, and I would call on members, all members, to support my Amendment 50. I'll speak to the amendments to Amendment 50 in marshalled order. Amendment 50E from Jackie Bailey would remove the words "use their best endeavours" in relation to care homes' duty to identify for every resident at least one individual as an essential care supporter. That would mean that care homes must identify an essential care supporter for all residents, no matter the circumstances of residence. I can't support this. In practice, there will be situations where sadly it isn't possible to identify someone because the resident has no family or friends. And some residents who do may have a very firm preference against designating someone as an essential care supporter for reasons of their own. The purpose of identifying essential care supporters is to give formal recognition to those people who actually perform that role. It's not to be a tick box exercise in which someone's name has to be recorded for every resident just to fulfil a legal requirement, nor is it to be an exercise of stripping care home residents of their personal autonomy. If they choose not to have an essential care supporter, that should be their right. For these reasons, I can't support Jackie Bailey's Amendment 50E. Jackie Bailey's Amendments 50F and 50G are, I think, connected. The overall effect is to prevent care homes from suspending visits without permission from Public Health Scotland or Scottish ministers or their delegate. I cannot support these amendments because they fundamentally misunderstand the different roles that are played by the different actors. Care providers are ultimately responsible for taking decisions about visiting. Of course, they don't do this in a vacuum. They take advice from others, including health boards, public health teams, as well as other bodies concerned with matters beside public health, for example, welfare issues. Public Health Scotland does not provide advice to care homes. That is the responsibility of teams working for health boards, which under the Public Health etc. Scotland Act 2008 have duties to protect the health of the public in its area. Amendments 50F and 50G cumulatively would undermine the proper role of care homes in taking decisions on visiting, taking account of public health and non-public health advice from a range of bodies, so I would urge Jackie Bailey not to move it. Amendment 50A, brought forward by Brian Whittle, is about communication with residents, essential care supporters, when visits are suspended, and I thank Brian Whittle for this amendment. Communication is so important. We had already intended to include within the Code of Practice guidance on communication, but having reflected on this amendment, we now want to go further. I think it would be worth going further than Amendment 50A, which is only about giving reasons in the context of a general decision to suspend visits. While I therefore agree with the intention of Amendment 50A, I invite Brian Whittle not to move it today and instead to work with me to bring forward something more comprehensive at stage 3. Amendment 50H from Jackie Bailey proposes that Scottish ministers should consider what steps are necessary to protect care homes from legal action in cases where an essential care supporter has been given access to a care home resident at a time when other visits have been suspended. It's not clear what this is intending to achieve. My Amendment 50 ensures that where visiting is to be suspended to prevent a serious risk, the provider must continue to support visits where they believe that the suspension of visits is causing or is likely to cause serious harm to the resident's health or well-being, and that harm outweighs the serious risk which led to the suspension of visits. In considering these risks, care providers should always act on advice from local NHS board, health protection teams, who under the Public Health etc. Scotland Act 2008 have duties to protect the health of the public in its area. It's not clear to me why Scottish ministers would want to take steps to protect care providers from legal action if providers have failed to follow public health or other advice to protect people. Furthermore, it is unclear how ministers would do this in practice, or indeed what would actually be required of them by this amendment, given that it would just oblige them to consider what steps are necessary. So on that basis, I cannot support Jackie Bailey's Amendment 50H. Amendment 50I from Jackie Bailey seeks to ensure that any decision to suspend visits must be reviewed every 48 hours and should remain in force for no longer than 7 days, and would require there to be an expedited appeals process for an essential care supporter, which would be considered by the body that granted permission for the suspension of visits and must be heard, and a decision no later than 72 hours after the appeal. These are all matters that can be dealt with by regulations in the code in due course, and are things that I would rather take the time to discuss with everybody concerned before committing to an approach that might be unworkable in practice or have serious unintended consequences. There are particular aspects of the way that Amendment 50I is drafted that I think could go particularly wrong, not least as it's predicated on an Amendment 50G being agreed to, which, as I've just said, I'm against. I can see, however, that there may be principles to be extracted from Amendment 50I that it could be valuable to have expressed in less problematic terms on the face of the bill. I therefore invite Jackie Bailey not to move Amendment 50I, and I'm very happy to discuss with her ahead of Stage 3 what should be for regulations or the code and what further amendments may be useful to reflect that on the face of the bill. Amendment 50J from Jackie Bailey would add to the list of matters that the Code of Practice is to identify as paramount considerations when care home providers are fulfilling the duties they've described by proposed Section 78A1 and 78B1. I agree wholeheartedly that the matters identified in Amendment 50J are important ones, but framing them as paramount considerations in relation to both of the duties is the wrong drafting approach. The point of the current framing is that there are two absolutely crucial paramount considerations with overarching effect across both the duty to identify essential care supporters and the duty to facilitate visits. These are, in summary, respecting and promoting the dignity, well-being and human rights of residents, and recognising and supporting the vital role that people who aren't care home staff, such as close relatives and friends, play in providing regular care. These, to my mind, are the two absolutely crucial paramount considerations that are relevant to both of the duties. Creating a long shopping list of paramount considerations risks distracting from the paramountcy of these two. If everything is a paramount consideration, then nothing is. The specific paramount considerations that Amendment 50J proposes cannot have overarching effect across the two duties. None of them have any relevance whatsoever to the first duty, and they are relevant only in limited circumstances in relation to the second. So Amendment 50J would put the matters it mentions simply in the wrong place in the bill. Beyond that, I do not think the specifics of the matters it mentions are quite right. The first of them would make a paramount consideration of the presumption that suspending essential care supported visits would cause serious harm. But as I've said, Amendment 50 makes that a legal presumption. It will be the law that care home providers have to apply it. It makes no sense to say they have to have regard to a presumption that they are legally required to follow. The second of the proposed further paramount considerations is that staff and essential care supporters are to work together as equals to agree how visits should be facilitated. I'm not clear what working together as equals would mean in practice, and I find there being no reference to involving the resident quite troubling. The last of the proposed further paramount considerations is the need for consistency of risk management processes for both staff and visitors. Now, obviously, staff are not the same as visitors. Risk management processes for staff will flow from their obligations as regulated professionals and through their employment contracts. If the suggestion is that staff are not to be made subject to any risk management processes that visitors cannot be subjected to, then that would cause serious problems. Amendment 50 already addresses most of the ground Amendment that 50J would deal with. I'm very happy again to speak to Jackie Bailey ahead of stage 3 about how we could make more explicit matters that the code must address. The way that Amendment 50J is constructed, however, both in terms of where it inserts the extra paragraphs and in what they say, is a problem, and I would urge Jackie Bailey not to move it. I turn to Brian Whittle's Amendment 50B with good news for him. I do support it. It would require the Code of Practice to be published in a manner that's accessible to the public, including in an easy read format. The Government intends to do just that, and so I'm happy to support an amendment saying so. We may, however, have to revisit at stage 3 the use of the phrase easy read, which doesn't have a concrete legal meaning, and naturally we will want to ensure that there is certainty about what the duty requires. In less good news for Brian Whittle, I do not support his Amendment 50C, which would require the Ministers to review the Code of Practice if a significant number of complaints were received about it. This would be judicialising a political matter in a way that's good for neither law nor politics. Amendment 50 already provides for the periodic review of the Code. Obviously, any government, if it were hearing significant discontent about the Code's terms, would use their powers to review it and change it if necessary. Involving courts in the matter and asking them to adjudicate on whether a number of complaints received by whom the amendment does not say are significant is not necessary or a good idea. And I'm afraid to say I also cannot support Brian Whittle's Amendment 50D. That would require ministers to report every year forever on the implementation of sections 78A to 78C in every local authority area. This would be a significant drain on public resources, and I'm not sure what the benefit of a routine reporting cycle like this would be. I hope that Brian Whittle will be reassured to know that the Care Inspectorate will assess care providers' compliance with the regulations, and that the Government already has plans to ensure that learning and improvement through a national oversight group for Anne's Law. I move Amendment 50.
Minister Jackie Bailey to move Amendment 50E and to speak to all amendments in the group.
Thank you very much, Convener, and I welcome the opportunity to bring these 6 amendments to committee, which seek to amend Amendment 50 in the name of the Minister. I believe that these amendments taken together will strengthen the rights of residents living in care homes to receive visits from those people who are important to them. Now, I welcome Amendment 50 as it's better than the original provisions in the bill, but as it stands, I genuinely don't believe that the Scottish Government's proposed amendment goes far enough in protecting the rights of care home residents to see their loved ones. I am genuinely worried that too much onus is being put on care home providers to make judgments, and the checks and balances that are in place are insufficient. And I think this is an area we absolutely must get right, and that's why I've lodged these amendments. As we know, Anne's Law is the result of campaigning by family members of people in care homes who were separated from their loved ones for long periods during the COVID-19 pandemic. And we know that this had devastating impacts on people's health and well-being. One of the greatest and most costly failures of the pandemic took place in Scotland's care homes. The cost in human lives was tragic, and the suffering caused unimaginable. Even as restrictions for the rest of the country eased, care homes remained under repeated lockdowns, we know causing harm and trauma for the residents and their families. Campaigners have been seeking a change in law to prevent this from ever happening again for many years now, and it's imperative that we pass legislation that will end this preventable harm. I want to take a moment to thank the Care Home Relatives Scotland Group for their continued efforts to see this change become a reality. Let me now address the amendments in turn. Amendment 50 strengthens the duty on care home providers to identify an essential care supporter for each resident. This is not, therefore, an optional extra, but neither is it a tick box exercise. It is a serious amendment to try and effect change. While Amendment 50J would require that the Code of Practice on care homes residents' rights to visits must provide that in following these duties, the following are considered, of course.
Thank you. A declaration of interest as a practising NHS GP. I'd like to just go back to Amendment 50E and talk a little bit more about essential care supporter and having somebody named, because, as you rightly said, during the pandemic, we saw an absolute failure when it came to Scottish care homes, and Anne's Law is absolutely fundamental because we all agree with it. We've all said for many years we want this to come in. My feeling is that an essential care supporter, somebody that is named, actually strengthens the rights of the individual that is there, and the idea that I believe, and this is the question, is that person would be a trusted source for the care home resident who might not be able to speak for themselves, and if they can, surely their voice is going to be heard louder than that of the essential care supporter. Is that the case, and do you think that this is actually quite a vital role to have?
Yes, that's absolutely the case. I couldn't have put it better myself, but it is essential. We've seen what's happened in the past. We need to reflect on that, and we need to make sure that the legislation we bring forward is as robust as possible, which is why we brought forward Amendment 50E. Let me move on to Amendment 50J, and in fulfilling the duties of the Code of Practice, we want considered the presumption of serious harm to residents where visits with their essential care supporters are denied, the requirement for care home staff and essential care supporters to work together as equals to agree how visits should be facilitated. That's not necessarily always the case, and the need for consistency of risk management processes for both staff and visitors. Amendments 50G and 50I are, in my view, essential if we are to get Anne's Law right. The former requires care providers to seek permission before they can suspend visits. This amendment states that the suspension of visits may only be granted by Public Health Scotland on health grounds, or Scottish ministers or a body delegated to make the decision on the behalf of Scottish ministers for any other reason. The latter would put in place important checks and balances regarding the suspension of visits, with any decision to grant a suspension being reviewed once in every 48-hour period by the body who granted the suspension and remaining in force for a period of no longer than 7 days. As it stands, there is a lack of an appeals process, which is why this amendment also allows for an expedited appeal to be heard and a decision issued no later than 72 hours after the appeal has been made. These amendments are critical because the process of suspending essential care supporters from visiting residents should require a high bar and appropriate authorisation. Some might argue that the renewal process for applications and appeals process is much too burdensome, but I fundamentally disagree. We need to get this right and ensure previous mistakes are not made again. Amendment 50F is consequential to Amendment 50G, and Amendment 50H would require Scottish ministers to consider what steps are necessary to protect care homes from legal action against them in cases where an essential care supporter has visited the care home while all visits have been suspended. I think this is important because we need to give the sector the confidence and reassurance that they will be backed in taking action to guarantee the rights of residents to be visited by their essential care supporter. The Feely Review identified the need for stronger protections for care home residents to maintain meaningful connections with loved ones, even during challenging situations like outbreaks, and it's therefore crucial that we ensure that these stronger protections are enshrined in the bill. It is important for us to get the balance right. I'm not convinced that the Minister has yet gone far enough, but I am more than happy to work with her, as she knows, and I would urge the Government to seriously consider the detail of my amendments. We have been talking about this for years now. The opportunity to strengthen amendments should not be missed. We can and we should go further, and whilst I will agree to withdraw 50I and 50J, I'm prepared to withdraw all if we have further discussions with the Minister on the whole suite of amendments prior to stage 3. Thank you, Convener.
Can I ask you to move your amendment, Ms Bailey, please?
I move.
Thank you. Brian Whittle to speak to Amendment 50A and the other amendments in the group.
Thank you, Convener. Like Jackie Bailey, I'm really pleased to see the Minister's Amendment 50 here. Again, agreeing with Jackie Bailey, I think that it does need more clarity. I don't think it goes far enough to support Anne's Law. 50A, as the Minister said, sets a requirement of care home service providers to provide a written reason to both the resident and essential care supporter in any case where a visit is denied. And this is an effort really to retain records as evidence for any future inquiries or evaluation of the implementation of the law. And I think that will be pertinent when I speak to 50D. I do welcome the Minister's comments around looking to go further than this, and welcome her offer to have further discussions of how we could strengthen this amendment, and therefore I won't press that one on this occasion. 50B places a requirement on the Scottish Ministers to publish the Code of Practice in a manner that is publicly available and provides an easy read format. Again, I welcome the Minister's support for that amendment, and her intention maybe to strengthen that. And I think it's really important that there is an easily accessible and easy read version of the bill, Code of Practice, especially in the understanding that many care homes experience mental decline more than the average population, and it's really important that this code is accessible to them. 50C provides a requirement on ministers to revise the code if significant problems have been reported. I think that is really important, because to trigger revisions to a code, if it clearly isn't working as intended, surely is what we want, and it also triggers revisions in a timely manner. 50D places a requirement on ministers to publish a report on the implementation of Anne's Law, broken down by council area each year. And I think, given what we're trying to do at 50A, I don't think it's particularly onerous, given that we're gathering evidence as we go along. It improves parliamentary scrutiny on the implementation, and will help to identify any areas that need additional support of implementation to make sure Anne's Law is in place for every person receiving care in a care home and their families. And surely that is what we are. We're all here to try and do. So I will be pushing 50D.
Thank you, Mr Biddle. Minister, to wind up on Amendment 50, please.
Thanks very much, Convener. This has been a long group, and it has been a long road to get Anne's Law right. Placing Anne's Law within the heart of this bill in primary legislation recognises our overall commitment to ensuring that people can see and spend time with loved ones. We've listened very carefully to those who've campaigned for Anne's Law and others to get to this point, and I believe that my Amendment 50, which takes account of what we've heard, is where we want to be to ensure that people remain connected. Importantly, my amendment formally recognises the role of essential care supporters, who are an integral part of the care team as called for by Care Home Relatives Scotland. It places a duty on care homes to identify essential care supporters, and it also provides a legal presumption that suspending visits from the person they are caring for will always cause serious harm to their loved one's health and well-being. I thank members for the other amendments in this group. Some of them sound reasonable on the face of it, but would be unworkable as they don't reflect current practice on the ground. Others would have unintended consequences. However, I do recognise the importance of a number of areas that have been brought forward. So my door remains open to discuss these suggestions ahead of Stage 3 with Jackie Bailey, with other members, but crucially also with members of Care Home Relative Scotland. In summary, I ask members to support my Amendment 50 and Brian Whittle's Amendment 50B, and to not support all of the other amendments in the group.
Thank you, Minister. Jackie Bailey, to wind up and press or withdraw Amendment 50E.
I am content on the basis of the Minister's concluding remarks not to press this amendment and the rest in the group in my name.
Thank you, Ms Bailey. I call Amendment 50.
Sorry, Jackie, can you just check, is Jackie Bailey withdrawing the amendment?
You're withdrawing the amendment? Yeah.
Yes, I'm not
yes,
moving.
That's what I thought.
Okay,
Thank you.
in that case.
Okay, the member wishes to withdraw Amendment 50E. Does any member object to the amendment being withdrawn? No. So now on to 50F.
On to 50F.
Yeah. I call Amendment 50F in the name of Jackie Bailey, already debated with Amendment 50. Jackie Bailey to move or not move?
Not moved.
I call Amendment 50G in the name of Jackie Bailey, already debated with Amendment 50. Jackie Bailey to move or not move?
Not moved.
I call Amendment 50A in the name of Brian Whittle, already debated with Amendment 50. Brian Whittle to move or not move?
I think given the Minister's helpful comments on revisiting and probably strengthening this, I will not move at this stage.
I call Amendment 50H in the name of Jackie Bailey, already debated with Amendment 50. Jackie Bailey to move or not move?
Not moved.
I call Amendment 50I in the name of Jackie Bailey, already debated with Amendment 50. Jackie Bailey to move or not move?
Not moved.
I call Amendment 50J in the name of Jackie Bailey, already debated with Amendment 50. Jackie Bailey to move or not move?
Not moved.
I call Amendment 50B in the name of Brian Whittle, already debated with Amendment 50. Brian Whittle to move or not move?
Moved, please.
The question is that Amendment 50B be agreed. Are we all agreed? I call Amendment 50C in the name of Brian Whittle, already debated with Amendment 50. Brian Whittle to move or not move?
Given the Minister's comments, I do think this is a really important area that needs to be explored further, but I will not move at this stage.
Thank you, Mr Whittle. I call Amendment 50D in the name of Brian Whittle, already debated with Amendment 50. Brian Whittle to move or not move?
Similarly, convener, not moved.
Minister to press or withdraw Amendment 50?
Moved.
The question is that Amendment 50 be agreed to. Are we all agreed?
Yes.
I call Amendment 138 in the name of Brian Whittle, already debated with Amendment 123. Brian Whittle to move or not move?
Not moved.
The question is that Section 40 be agreed to. Are we all agreed?
Yes.
I call Amendment 89 in the name of Katie Clark, grouped with Amendment 90. Katie Clark to move Amendment 89 and to speak to both amendments in the group.
Thank you, Convener. I would like to speak to my Amendment 89, which requires regulations to be brought forward on the reporting of tax and ownership status of publicly owned care, and Amendment 90, which seeks to extend freedom of information rights to publicly owned care. The Minister was kind enough to meet with me along with her officials yesterday and offered to have further discussions before stage 3. I indicated to the Minister that I would not be planning on pushing either amendment to the vote today and was very open to discussions about the drafting of the amendments. There were specific issues relating to the definition of care, and I would advise that the definition I would be seeking to rely on is the definition in the Community Care and Health Scotland Act 2002, and of course that is a matter I would be happy to discuss. The background, of course, is that we have moved away from a care sector which was dominated by publicly owned and run organisations providing publicly paid for care. Of the 42,489 registered care home places in March 2022, 77% of registered care home places in Scotland were in private run care homes, and 80% of staffing in care homes is in the private sector. There is a significant market concentration, with the 10 largest for-profit care homes providers accounting for more than a third of registered places in much of Scotland. A significant number of organisations are registered outside the UK and involve private equity and real estate investment trusts and US-based hedge funds. Across the UK, the 5 largest chains amount for nearly 20% of beds, according to work from 2016. To use one example that members may be aware of or indeed may have been involved in as constituency, representatives is the consequences of the collapse of Southern Cross, owned by Blackstone, in 2011, which affected 31,000 care home residents, including in the constituency that I represented at that time. Many of these Southern Cross care homes were sold to Four Seasons Healthcare, a company owned by Jersey-based Terra Firma Private Equity. In April 2017, 220 care homes and 17,000 residents were affected when that organisation too became bankrupt. Four Seasons, like many other private equity operations, consist of complex corporate structures. The Financial Times reported that it consisted of 200 companies arranged in 12 layers in at least 5 jurisdictions, including several offshore territories. Tax avoidance and profit shifting were central to the operations. The principle behind both my amendments today is of transparency, and that we should follow the public pound, and that where there is publicly funded care provided by organisations other than public authorities, both freedom of information rights should exist, and transparency in relation to tax and ownership. As the committee will be aware, at the moment, freedom of information rights do not exist outside public authorities. This was particularly evident during COVID, where information that relatives were able to obtain using rights that they had with local authority providers were not available from other providers. And Jackie Baillie has already spoken this morning about the experience of families during COVID. When the Scottish Parliament passed the Freedom of Information Scotland Act in 2002, it was designed to be flexible and to enable the addition of name providers or categories under Section 5. In reality, this has been rarely used by ministers. After COVID, both families of care home residents, but also freedom of information campaigners, are frustrated at the lack of progress. MPs themselves expressed their frustration in 2013 when updating designations under the Freedom of Information Scotland Act resulted in an amendment which required reports from ministers every 2 years on the use of the Section 5 power. Despite that, this power has basically been used to report that no action has been taken. There was a Scottish Government consultation in 2019 on the use of Section 5 powers, and care was one of the examples that was focused on, which could have resulted in an extension to care services, but the Scottish Government decided not to progress that. In May 2022, the Public Audit and Post-Legislative Scrutiny Committee of this Parliament reported in its inquiry on the operation of the Freedom of Information Scotland Act that public sector bodies delivering public sector services should be subject to freedom of information rights. And consistently, the Scottish Information Commissioners have called for the designation of providers of health and social care, especially following the COVID pandemic. Repeated polling by the Commissioner has shown public support for this principle, and indeed in the consultation that I held for my members' bill on freedom of information in 2022, there was overwhelming support for the principle. Yes, of course, I'd be happy to take an intervention.
Thank you. A couple of questions. I wonder if Katie Clark would acknowledge that private care homes are paid less to provide a service than the local authority pay themselves. Thus, there is a significant saving to be made by the public's purse by having private care homes, and it's not, as seems to be portrayed, to be a very evil entity. It isn't that, and we do save a lot of money. Would you also answer my question about if a company that provides some public work but then also does other things, a freedom of information could be used by other companies to look into detail of that particular company and look at very sensitive information, gaining an advantage in not just the public space but in real private services. And does this not risk us losing private care homes from a position where it saves the public money?
The member has raised 2 points, and I will attempt to respond to both. The first point obviously relates both to the cost, but I suppose the quality of care provided in the private sector. And of course it is the case that most private care companies and organisations in Scotland provide a good quality of care. But the principle, I think, has to be that if the public sector is paying for a service, that we should have access to a very basic level of information, and that is the principle. That indeed was the intention behind the 2002 Act. However, the steps have not been taken to extend freedom of information to the sector. And as I've indicated, there is a percentage of the sector that has been financialised. And the Southern Cross is an example, but it's only one example. And when things go wrong, that can be very serious for the individual and indeed their families. So we need robust models, and when we're funding it, as taxpayers, we need to make sure that we are satisfied, that we are providing that level of service and that security for residents. On the second point, this is a live issue that we've clearly grappled with my members' bill. And just to be clear, it's the aspects of a service that is funded by a taxpayer and the parts of an organisation that deliver publicly paid for services that would require to be compliant with FOI rights, not parts of the organisation that are funded in other ways. So that would be the principle in terms of how freedom of information would operate for organisations who provide both public sector but also other private work to individuals. My amendments are drafted in a narrow way. Amendment 89 requires ministers by way of regulation to specify requirements for bodies providing publicly funded care services in relation to transparency of ownership and tax status, and would require a higher degree of transparency from non-publicly owned bodies who provide care which are funded by the taxpayer, which I think is addressing the member's point. Amendment 90 would require the extension of freedom of information to care providers for the reasons I've already outlined. And I understand that the Minister is likely to say from my discussions with her yesterday that a further consultation will take place. And I would submit that a very clear message needs to be made by this Parliament that we expect transparency where the public pound is being used to pay for care, for freedom of information rights and for tax and ownership. And I look forward to discussing those matters further as this bill proceeds.
Thank you, Ms Clark. Can you move your amendments, please?
I move both amendments.
Thank you. Minister.
Thank you, Convener. I can't support either of the amendments in this group. Amendment 89 would place the duty on ministers to make regulations imposing requirements on care service providers who are publicly funded. It's unclear what the limit to that power is. On its face, the amendment suggests that they could be amendments about anything. That does seem a bit broad. But there are two particular things the amendment says the regulations have to impose requirements about: tax status and transparency of ownership. It's unclear what these requirements would be or what could be done to any provider not complying with whatever they are. It's also unclear which services it would apply to. Beyond the challenges posed by the drafting, the amendment would potentially cause problems with compliance with the UK Internal Market Act, which Katie Clark's colleagues at Westminster have, of course, refused to abolish. It may be that some or all of what Katie Clark is seeking to achieve with these amendments can already be done. Public bodies already have powers to exclude providers through Regulation 58 of the Public Contracts Scotland, Regulations 2015 and Regulation 9 of the Procurement Regulations 2016. That includes excluding providers who have breached their obligations relating to the payment of taxes or social security contributions. My door is always open if Katie Clark wants to discuss further what can be done to address any specific concerns that she has. But Amendment 89, I believe, is the wrong answer to those concerns. Amendment 90 would extend the requirements of the Freedom of Information Act to persons providing publicly funded care services, and I understand the desire to improve access to information about care services, and I agree that access to information is critical. in fostering public trust and in ensuring the effective delivery of services. That's why the Government's already committed to consult on the extension of the Freedom of Information Law to private and third sector care homes and care at home services. Amendment 90 is not the way to take forward that change. The right way to take forward change in this area is through the existing power under Section 5 of the Freedom of Information Scotland Act 2002 that allows for and requires specific consultation, ensuring that any extension of freedom of information law is properly planned and tailored to the specific needs of the sector. It means in particular that there's an opportunity to consult to get an appropriate definition of the bodies that would be making subject to freedom of information requirement. The expression used in Amendment 90, which is publicly funded care service, is unclear and I think may cover more bodies than Katie Clark really intends it to. There are around 11,000 care services registered with the Care Inspectorate, and many of those services are delivered in partnership with private and third sector providers of varying sizes. Being subject to freedom of information laws does come with certain resource implications, and these do have to be carefully considered in deciding which bodies to extend them to, especially in the context of a sector already facing substantial financial challenges following the recent national insurance hike. I note that the Coalition of Care and Support Providers in Scotland, CCSP, have indicated to the committee that they don't support this amendment, citing their concerns about the resource implications of new obligations to be placed on providers. I therefore ask Katie Clark not to move Amendment 90, and I'll be pleased to discuss with her in advance of Stage 3 the work that the Government's already got underway in relation to access to information rights in the sector and the other avenues for making progress on this important issue.
Katie Clark to wind up and press or withdraw Amendment 89.
Thank you, and I look forward to discussing these matters with the Minister further. As I said, I don't plan to push either amendment to the vote today. And what I would say to the Minister, however, is that there's a great deal of frustration about the delays there have been in extending freedom of information within the care sector, particularly following the experiences of COVID. However, I will discuss that further with her before Stage 3. And in relation to tax and ownership, I think given the nature of the changes that have taken place in the care sector, we need the information about the ownership structures and tax status, because we do not want to be in a position again where residents are basically being evicted because care homes are going bust in situations where there's very complex and non-transparent ownership arrangements. So I would argue we should learn from the lessons of history to try and ensure that we are not put in that position again. But I don't plan to push either amendment to the vote, Convener.
Thank you, Ms Clark. Katie Clark wishes to withdraw Amendment 89. Does any member object? No. Call Amendment 51 in the name of the Minister, group with Amendments 52, 53, 53A, 54 and 55. Minister to move Amendment 51 and to speak to all amendments in the group.
Thanks very much. The Feely review was clear that while there are some areas of good practice, procurement needs to improve. It needs to be ethical, outcome-focused, person-led, flexible, collaborative and embed fair work. While I'm confident the current suite of procurement legislation already provides the flexibility to deliver most of the improvements needed, there are two areas where changes to legislation would be of benefit. They are extending the reserved contracting process to third sector organisations that meet the listed criteria for services, and providing a new ministerial power to amend the light touch regime threshold. Before turning to the detail of my amendments on the reserved contracting process, I want to take this opportunity to reiterate my appreciation to all providers who deliver vital services to our communities. I'm aware there has been some concern about what this process means for the market, and I want to be clear. We need a mix of third sector, for-profit and public sector organisations to provide social care throughout Scotland. The extension of the reserved contracting process will not change this. For providers that do not meet the criteria to participate through that process, they will still have access to other contract opportunities through different procurement routes. On the detail of the amendments, Amendment 51 removes the limit on the duration of a contract that can be made subject to the reserved process. Representatives of the third sector told us the Year 5 limit proposed in the bill as introduced would be unhelpful. As a result of Amendment 51, the decision on the length of a contract subject to the reserved process will be made on a case-by-case basis by the relevant public body. Amendment 52 is a tidying up amendment to replace a reference to services being provided to or on behalf of the National Care Service in consequence of the removal of Part 1 of the bill. Amendment 53 broadens the definition of the bodies that will qualify to bid for contracts through the reserved processes. This This reflects extensive work undertaken with stakeholders to ensure the criteria fulfil the policy intention of ensuring that third sector organisations, including social enterprises, can bid through the process. I want to thank all the stakeholders involved for their invaluable feedback. Amendment 54 is a minor drafting and adjustment. Before moving on from the reserved process, I would urge members not to support Brian Whittle's Amendment 53A. The purpose of Section 41 of the bill is to create a process for bidding for certain contracts that is open only to third sector organisations, so they are not always crowded out by big for-profit companies. Brian Whittle made clear last week in speaking to his amendment to remove Section 41 that he is opposed to this in principle. His amendment would imply that the state should have no role in providing a level playing field to ensure the sector has an appropriate mix of for-profit and not-for-profit providers. His Amendment 53A is more of the same. It would allow companies that are principally set up to make profit for their shareholders or members to enter the reserved process, provided they say they do not intend to use profits from reserved contracts for private gain. This would still be opening the reserved process up to organisations beyond third sector, which are the organisations Section 41 was designed to benefit. This is understandable from Brian Whittle, who we know is opposed to the whole principle behind Section 41, but members who are not should vote against Amendment 53A. Finally, on this group, I turn to Amendment 55. Procurement legislation details the rules that apply when public sector bodies purchase from external providers. It sets thresholds at which rules, like requirements for specific competitive processes, apply. The rules depend on the type and value of what's being purchased. For health and social care services, the light touch regime threshold and rules apply. There is currently no mechanism for changing the threshold of the light touch regime, and the current threshold has been in place since 2015. Amendment 55 would provide a power to change the threshold by regulations for health and social care contracts. Any future changes to the threshold must be exercised in compliance with international law, including trade agreements, and would be subject to the negative procedure. I move Amendment 51.
Thank you, Minister. Brian Whittle to speak to Amendment 53A and other amendments in the group.
Thank you, Convener. I think the concern I have with 53 is that such a change may compromise the discretion of care commissioning bodies in their efforts to deliver services most efficiently and effectively. I'm concerned that might lead to imperfect choices being forced to be made, delivering less service for the same taxpayer costs. In my Amendment 53 I accept as a probing amendment, really, but it broadens the set of qualifying organisations for reservable contracts by only requiring the area of their operation in relation to the reservable contract to be a non-profit nature rather than the whole organisation. As I say, it tightens the language around the types of contracts the government intend of reservable contracts only, but I accept it's a probing amendment and really wanted to give the Minister an opportunity to respond to that. Convener.
Thank you, Mr Whittle. Minister, to wind up.
Thanks very much. Procurement can and should be the enabler of the much needed improvements to social care, and the light touch regime provides flexible rules to procure social care services over a certain value. There's currently no way for us to change the value at which the rules apply, and Amendment 55 gives us that power. As I said previously, we rely on a wide range of service providers to meet the needs of the people of Scotland. I appreciate all the work they have and continue to do to deliver these vital services to people. The reserved contracting process is one of many approaches that can be taken when procuring. The decision on whether to use this process will be made at local level. The ethical commissioning and procurement principles will be at the centre of all decision making. That includes decisions on which procurement approach to use. My proposed amendments 51, 52, 53 and 54 will update the defining criteria of the reserved contracting process and remove the limitations on contract durations through that process. People and the sector have told us how they would define the third sector. We've listened to them, and the amendments that I propose reflect this work. On this basis, I urge the committees to support amendments 51, 52, 53, 54 and 55 in my name, and not to support Brian Whittle's amendment 53A.
Thank you, Minister. The question is that Amendment 51 be agreed to. Are we all agreed?
Yes. No.
The committee is not agreed. We will have to vote. Those members in favour of Amendment 51, please indicate. Those against? Abstentions? Eight members voted in favour of Amendment 51, 2 against, and therefore the amendment is agreed to. The question is that Amendment 52 be agreed to. Are we all agreed?
Yes. Sorry, the Minister needs to move the amendment first.
Minister, can you formally move the amendment? Thank you. The question is that Amendment 52 be agreed to. Are we all agreed? Yes. Call Amendment 53 in the name of the Minister, already debated with Amendment 51. Minister to move formally.
Moved.
Call Amendment 53A in the name of Brian Whittle, already debated with Amendment 51. Brian Whittle to move or not move?
Not moved.
Minister, I take it you wish to press Amendment 53 as it's not been amended. The question is that Amendment 53 be agreed to. Are we all agreed?
Yes.
No, the committee is not agreed. There will be a vote. Those members in favour of Amendment 53, please indicate. Those against? Abstentions? Eight members voted in favour of Amendment 53, 2 voted against. There were no abstentions and therefore the amendment was agreed to. I call Amendment 54 in the name of the Minister, already debated with Amendment 51. Minister to move formally.
Moved.
The question is that Amendment 54 be agreed to. Are we all agreed?
Yes.
I call Amendment 139 in the name of Brian Whittle, already debated with Amendment 123. Brian Whittle to move or not move?
I think the Minister's comments around my intention to leave out the whole Section 41 is non-reflective of what I was trying to do, which was quite frankly to take all the sections that are left out of the bill and start again and deliver a better bill than this currently is. But as we discussed last week, I think at this stage I will not move.
Thank you, Mr Whittle. The question then is that section 41 be agreed to. Are we all agreed? Yes. Thank you, and I'm going to briefly suspend the meeting. I call on Amendment 55 in the name of the Minister, already debated with Amendment 51. Minister, to move formally.
Moved.
The question is that Amendment 55 be agreed to. Are we all agreed?
Yes.
I call Amendment 56 in the name of the Minister in a group on its own. Minister, to move and speak to Amendment 56, please.
Apologies. Sorry, is it 14? Apologies. Thank you, Convener. My Amendment 56 will give the Scottish Social Services Council a power to compel written information from various sources such as employers, witnesses and other public bodies where this is pertinent to the exercise of their functions, including fitness to practice investigations. This will mean that they will no longer need to make an application to the court through Section 1(1) of the Administration of Justice Scotland Act 1972 and Chapter 3, Part 1 of the Act of Sederant Summary Applications, Statutory Applications and Appeals, etc. Rules 1999 for such information where it's not provided voluntarily, thereby reducing the time taken for an investigation and the costs involved. I move Amendment 56.
Thank you, Minister. Sandesh Gohani.
Thank you. I wonder if the Minister could clarify a couple of things for me on her amendment. In a legal sense, a person can refer to individuals, businesses, organisations, but potentially is limited by the provision of their legislation. And so what I would like to know is whether there are such limitations within the legislation, and also whether there are any restrictions in the full legislations or definitions governing this power.
So I'm happy to discuss those questions with Dr Galhani offline. This is a relatively uncontroversial process which has been, people have asked us to do this to strengthen the powers of the SSSC. I'm content to discuss any concerns with Sandesh Galhani between now and stage 3.
Thank you. No other members indicated they wish to speak. Minister, to wind up.
No need to wind up.
Thank you, Minister. The question is that Amendment 56 be agreed to. Are we all agreed? Yes. Committee's not agreed, so we'll move to a vote. Those members in favour of Amendment 56, please show your hands. Those against? Abstentions? Eight members voted in favour of Amendment 56. There were no votes against. There were 2 abstentions. Therefore, the amendment is agreed to. I call Amendment 57 in the name of the Minister in a group on its own. Minister, to move and speak to Amendment 57.
As the development of the National Care Service, the National Social Work Agency and related policies progress, we must ensure that the appropriate bodies are able to undertake all necessary activities in a cohesive and complementary way. My Amendment 57 simply provides clarification in relation to an existing power that Scottish ministers already hold. They can already delegate to the Scottish Social Services Council or authorise other relevant persons to undertake on their behalf any of the functions under Section 58 of the Regulation of Care Scotland Act 2001. Amendment 57 simply clarifies that a function can be delegated in part as well as entirely. For example, a function may be delegated only insofar as it relates to a particular workforce. I move Amendment 57.
No other member has indicated that they wish to speak. Is there anything further you wish to contribute, Minister?
No, thanks.
The question is that Amendment 57 be agreed to. Are we all agreed? Yes. The committee is not agreed, so we'll move to a vote. Those in favour of Amendment 57? Those against? Abstentions? Thank you. 8 members of committee voted in favour of Amendment 57, 2 against, and there were no abstentions. Therefore, the amendment is agreed. I call Amendment 140 in the name of Brian Whittle, already debated with Amendment 123. Brian Whittle, to move or not move?
Not moved, Convener.
Thank you. The question is that section 42 be agreed to. Are we all agreed?
Yes.
I call Amendment 141 in the name of Brian Whittle, already debated with Amendment 123. Brian Whittle, to move or not move?
Not moved, Convener.
The question is that section 43 be agreed to. Are we all agreed?
Yes.
I call Amendment 90 in the name of Katie Clark, already debated with Amendment 89, and I note that Ms Clark is not in the room with us. Does anyone else wish to move that amendment?
No.
I call Amendment 142 in the name of Sandish Gohani, grouped with Amendment 154. Sandish Gohani, to move Amendment 142 and to speak to both amendments in the group, please.
Thank you, and I move the amendment. So I felt that it was important that we give the Care Inspectorate commensurate powers to be able to deal with all of what is happening within this legislation. I feel that we're able to strengthen their hand, and we're able to provide a system for complaints to be created within going to the Scottish Care Inspectorate, and to be able to then thus increase the resources as required for the extra work that they're going to be doing. And my other amendment, 154, is simply to make this an affirmative process.
Minister.
I can't support either of Sandish Galhani's amendments. They require ministers to make regulations for matters already dealt with by the Public Services Reform Scotland Act 2010. I don't know what additional powers Sandish Galhani envisages the regulations would give to the Care Inspectorate. It's not clear what sanctions the regulation-making power could put in place to back any new powers it gave the Care Inspectorate, nor is it clear how those new powers would sit alongside those already within the 2010 Act. If Dr Galhani feels there are specific gaps in the Care Inspectorate powers, I would be happy to discuss what can be done to address that ahead of stage 3. But requiring ministers to use subordinate legislation to make unspecified changes for a vaguely defined purpose in an area where primary legislation already governs what can be done by the Care Inspectorate and indeed other bodies, including the Scottish Social Services Council and the Scottish Public Services Ombudsman, is legally and constitutionally the wrong way to go about closing whatever the perceived gap might be. I would ask the committee not to support Sandish Galhani's amendments 142 and 154.
Sandish Gohani, to wind up, press or withdraw Amendment 142.
So I feel that it's very important that we do create a system for complaints to occur, and the inspectorate, the Care Inspectorate, seems to be a good route for that to happen and improve local standards. I have heard what the Minister has said, and I will withdraw.
The member has indicated that he wishes to withdraw Amendment 142. Does any member object? Thank you. I call Amendment 58 in the name of the Minister in a group on its own. The Minister to move and speak to Amendment 58, please.
Adult support and protection is everyone's business. We all have a responsibility to support and protect the most vulnerable in our society, and we want to make it as easy as possible for those at risk of harm to receive the right support at the right time. For clarity, local health and social care partnerships continue to hold the overall responsibility for investigating and supporting adults that may be at risk of harm. I've heard from a wide range of stakeholders, including from health, social work and police, that the variation in how adult protection guidance, including profession-specific guidance, is applied across Scotland can leave them unsure of the most appropriate action to take when they have concerns about an adult at risk. Amendment 58 seeks to address this by clarifying that where there are concerns about an adult at risk, information can be shared quickly, proportionately and safely between independent healthcare providers, including private providers and the local authority. It will also allow relevant healthcare services to contribute to adult protection committees who take strategic action on improvement, governance and planning. The amendment will improve consistency and reduce variation when supporting and protecting our most vulnerable adults across Scotland. I move Amendment 58.
Thank you, Minister. No other member has indicated that they wish to speak. Is there anything further that you wish to add? No. The question is that Amendment 58 be agreed to. Are we all agreed? Yes. I call Amendment 59 in the name of the Minister and a group on its own. Minister to move and speak to Amendment 59, please.
Social work plays a unique and crucial role impacting and influencing the lives of people across the entire age spectrum. The Feely Review identified that social work services are disjointed and inconsistent, and that our dedicated professional social workers need more and better support to help them in the challenging roles that they undertake. A national social work agency will provide strategic national leadership to the social work profession, driving change and continuous improvement across Scotland. Working in partnership with sector partners, we seek to build a sustainable, strong and highly skilled workforce for the future, from student to senior leader. The profession is regulated and the social worker title is protected by law. Therefore, formalising the existing role of the National Chief Social Work Advisor in statute signals its importance and centrality to the social work profession. The National Chief Social Work Advisor will champion the vital cross-cutting function of social work, bring strategic leadership at a national level and advance the position of social work nationally. In partnership with the sector, the National Chief Social Work Advisor will drive the development of a sustainable, highly skilled workforce and strengthen cohesion through enhanced leadership of the social work profession. I move Amendment 59.
Thank you, Minister. Sandesh Gohani.
Thank you. The role of the National Social Work Advisor sits within Scottish Government, I believe, at Deputy Director level. I think that if the Minister is looking to create a National Social Work Agency around the National Social Work Advisor, where that person is at Deputy Director level, it undermines the level of the person that is going to be doing that role. For equality, for ability for our healthcare professionals, especially how vital social workers are when it comes to the care sector, and we need to see this post put at a director level to enable the post holder to be able to access all meetings and to have a level which is commensurate with other professions. And so I do really worry that all this work is going to be put around somebody that really should be sitting at a director level, as is with other people that have similar roles.
So, to strike a note of consensus, I agree that the social work profession is vitally important, and that the professional leadership provided by the Office of the Chief Social Worker should be recognised and should have an appropriate status. The grade of that individual is not specified on the face of the bill, so whilst I agree with the premise of what Sandesh Gohani is saying, I don't think it's necessary to specify the grade of the Chief Social Worker on the face of the bill. Yeah.
Would the Minister consider increasing the level of the National Social Work Advisor to that of a director?
I think we're getting into controversial territory here. The member will understand that ministers don't specify the grades of civil servants in the government, but I'm happy to discuss the situation with the member between now and stage 3, but I don't think it is appropriate to specify the grade on the face of the bill.
Minister, are you finished winding up? Thank you. The question is that Amendment 59 be agreed to. Are we all agreed? Yes. The committee is not agreed. There will be a vote. Those in favour of Amendment 59, please indicate. Those against? Abstentions? Eight members voted for Amendment 59, 2 voted against, therefore Amendment 59 is agreed to. Call Amendment 143 in the name of Brian Whittle, grouped with Amendments 144, 147 and 157. Brian Whittle to move Amendment 143 and to speak to all amendments in the group.
Moved, Convener, thank you. The recommendations from stage 1 of the report really is what has prompted these amendments. And I quote from the stage 1 report where it says, irrespective of the model of accountability, the committee believes proposals for the creation of a National Care Service need to be accompanied by a reinforced role for the Scottish Parliament in undertaking regular, structured scrutiny of its implementation and the extent to which it's achieving its defined objectives. To support this reinforced scrutiny role, the committee calls for the bill to include provisions enabling the Scottish Government to keep the Scottish Parliament regularly updated on the operations of the National Care Service, including, in particular, an assessment of the extent to which this is contributing to improved outcomes for those in receipt of social care, which I would suggest, Convener, is what this bill is all about. 143 puts a duty to report on Frank's Law, again improving parliamentary scrutiny on its implementation. It will help to identify any areas that need additional support of implementation to make sure Frank's Law is in place for every person entitled to personal care. 144 places a duty on ministers to publish a report on the equality of social care services by local authority area. The Government's original intention behind this bill was to reduce inequality in care services across Scotland. I'm sure, along with everybody else, supportive of reducing health inequalities, including those occurring in care spaces. It's important to gather data on where services are unequal and to be able to know how to address this problem in the future. It is also important to measure the impact of this bill on equality of services. 147 places a duty on the ministers to report outcomes contained within this bill to Parliament. Much of the bill will be revised at stage 2, and if it passes fully, I think it's important to understand what the bill is achieving for all those in need of social care and those working in the sector. 157, again, during the evidence session, stakeholders were very concerned about the financial aspects of this bill, and the committee had particular concerns around the financial memorandum of Part 2, Health and Social Care Information. I think given the significant number of amendments and revisions to the bill, I think it's important that the costs of the bill are quantified. This will ensure that the Government is able to budget appropriately in the future and will ensure provisions within the bill are funded unless the Government chooses otherwise. Convener.
Whittle, Minister.
I can't support any of the amendments in this group. I understand the intention behind Amendment 143, which would require an annual report and the provision of personal care to under 65s, and I too value robust data collection, but I can confirm that the information required by Amendment 143 is already published on an annual basis in relation to personal care, and therefore the intent behind Amendment 143 is already being met. If the member's intention was to require any additional information to be published, it fails to require that, and I consider it should not be supported. It's not clear what the intention of Amendment 144 is. As drafted, I can't support a duty. I do not understand. Having heard what Brian Whittle has to say about the amendment, I'm not sure that equality of services is the right expression. The legal effect, if this amendment were agreed in its current terms, would be unclear. So I invite Brian Whittle not to move it, and I'm happy to discuss this particular proposal in advance of stage 3. Amendment 147 would require a publication of a report in the Act's operation every 2 years forevermore, and I can't support this perpetual drain on public resources that has no clear purpose. The delivery of the National Care Service will, as I've explained, be about so much more than what is done in this bill alone. A report as envisaged would therefore only tell part of the story, and it would be a very disjointed story at that, given that most of what's in the bill are amendments to existing legislation. It's hard to understand what sort of report Brian Whittle's envisaging, and that would comment only on arrangements to the extent that the legislation underpinning them is amended by this bill. A report in the terms proposed by Amendment 147 would be bizarre and add nothing to existing mechanisms available to this Parliament and the public for scrutinising the health and social care system overall. So I urge members to reject it. Finally, I urge members to reject Amendment 157, which would prevent the Act resulting from the bill from being commenced until ministers prepare a report on the estimated costs arising from the bill of the Act. This, alongside the amendments to leave out all of the bill sections, is simply another wrecking attempt by Mr Whittle, and I would urge members to reject this amendment as they have rejected those others. The financial implications of this bill as amended after stage 2 will be subject to scrutiny in the usual way when the supplementary financial memorandum is produced. The Finance and Public Administration Committee will scrutinise that in the usual way, and there are ample routes for this committee or any other member of the Parliament to obtain information about costs from the Government at any time. This amendment is simply an attempt to put a completely unnecessary procedural hurdle in the way of getting on with improving the flow of information through our health and social care systems, delivering breaks for carers and delivering Anne's Law.
Sanders Gohani.
Thank you. I'd just like to pick up on one thing. I find it odd that the Minister talks about wrecking when she herself has removed Section 1 of the bill and has multiple amendments which in effect wreck the original bill that the Scottish Government laid.
Do you wish to come back on that point? Brian Whittle to wind up and press or withdraw Amendment 143.
Thank you, Convener. I hear what the Minister says around 144. Welcome the opportunity maybe to discuss that further. I find it quite strange, though, the Minister says that there's already reports on this, like 143 and 143, that there already report on this, given that the recommendation of this committee was that there is a reinforced role to be undertaken, that regular structured scrutiny. So that is against what the Minister says, is against what this committee has found. I think one of the issues we have is that just because we aren't collecting the data is no reason why we shouldn't collect the data. And I think if we have an ongoing managed collection of data, it means that accountability is much easier to deliver a report. In terms of this idea of not understanding how much the bill will cost before putting the bill into place, I find very, very strange. I think when we're deploying public money, I think it's really important that we understand where that money is going and how much it's going to be. So I find the Minister's arguments against 157 quite puzzling, but I will press 143.
Thank you, Mr Whittle. The question is that Amendment 143 be agreed to. Are we all agreed? No. Committee's not agreed. We will have a vote. Those in favour of Amendment 143, please indicate. Those against? Abstentions? Four members voted in favour of Amendment 143, 5 members voted against, and there was 1 abstention. Therefore, the amendment is not agreed. I call Amendment 144 in the name of Brian Whittle, already debated with Amendment 143. Brian Whittle to move or not move?
I'll take the opportunity to work with the Minister on this one, and at this point I will not move.
Thank you. I call Amendment 145 in the name of Brian Whittle and a group on his own. Brian Whittle to move and speak to Amendment 145.
Sorry. This is again a recommendation from Stage 1 report. It said again, 145 you said again? Yes. Sorry. Irrespective of the model of accountability, the committee believes proposals should be for the NCS should be accompanied by a reinforced role for the Scottish Parliament undertaking regular structured scrutiny of its implementation and the extent to which it's achieving its defined objectives. In particular, there should be an assessment of the extent to which it is contributing to improved outcomes for those in receipt of social care. I think this is central to the discussion of this bill and has been put as the issue of delayed discharge. This amendment seeks to place a statutory duty on ministers to eradicate delayed discharge. They've already pledged to eradicate it, so why not make this target binding? This is intended to force the government to consider all options when tackling delayed discharge, as their current approach is clearly not working. In December 2024, there were 61,706 days spent in hospital by people whose discharge was delayed, which is a 6% increase on the number of delayed days from December 2023. That comes from delayed discharges in NHS Scotland monthly figures, Public Health Scotland, 4th of February 2025. Convener.
Moved. Thank you. Minister.
Whilst I welcome Brian Whittle's focus on delayed discharge, which is a key priority for the Scottish Government, I would urge members not to support Amendment 145. I am absolutely clear that the current number of people delayed in hospital and the considerable variation in the level of delays across different parts of Scotland is unacceptable, and I agree that every feasible option to support a reduction must be considered. However, I do not believe that a statutory target in the bill as it stands will drive such a reduction. We know that shifting the balance of care from hospital to the community and ensuring that best practice in integrated discharge processes occurs is what will make a difference here. That requires careful work across health and social care systems. The statutory duty for providing social care services sits with local authorities, and the challenge in addressing delays is complex. That's why efforts to drive improvements must be rooted in collaborative engagement and support, not arbitrary targets. Since last July, the Scottish Government has been working collaboratively with COSLA and health and social care partnerships to explore the challenges that local systems face, offer support to those with the highest levels of delays, and identify and promote best practice. That work will be supported by the commitments in our latest budget to enhance hospital at home, improve frailty pathways, and to make sure that people get the care they need in the right place for them. On reporting and the requirement for a parliamentary statement in Amendment 145, we already have monthly reporting on delayed discharge by Public Health Scotland, and as the committee will be well aware, there are very regular exchanges in the Chamber about those figures and the challenges associated with improving flow and integration across health and social care services. It's not clear what more this requirement would add to accountability, including the local accountability of local authorities. On that basis, I cannot support Brian Whittle's Amendment 145, and I would urge members not to support Amendment 145 either.
Thank you, Minister. Brian Whittle, to wind up and press or withdraw Amendment 145.
I think the Minister makes a really interesting point around collaborative working, which is exactly how I think we tackle this problem. A problem which the Government had already committed to eradicate some time ago. So whatever the Government's doing just now is not working. And some of that collaborative working should be around the implementation and adoption of technology, which was another one of my amendments that the Minister voted or asked to be voted against. So I think that what we're trying to do here is put a focus on delayed discharge, because it is a significant issue, not just for social work, but in NHS as well. I think reduction of 25% per year, I think, is eminently doable if we do the right things and if we do that collaborative working as the Minister suggests. So I will be pressing this amendment.
Thank you, Mr Whittle. The question is that Amendment 145 be agreed to. Are we all agreed? No. Committee's not agreed, so there will be a vote. Those in favour of Amendment 145, please indicate. Those against? Abstentions? Four members voted for Amendment 145, 5 against, and there was one abstention. Therefore, the amendment is not agreed. I call Amendment 146 in the name of Brian Whittle, already debated with Amendment 100. Brian Whittle, to move or not move?
Not moved.
I call Amendment 147 in the name of Brian Whittle, already debated with Amendment 143. Brian Whittle, to move or not move?
Moved.
The question is that Amendment 147 be agreed. Are we all agreed? No. Committee's not agreed, so there will be a vote. Those in favour of Amendment 147? Those against? Abstentions? Four members voted in favour of Amendment 147, 5 against, and there was one abstention. Therefore, the amendment is not agreed. Call Amendment 60 in the name of the Minister, already debated with Amendment 1. Minister, to move formally.
Moved.
The question is that Amendment 60 be agreed. Are we all agreed? Yes. I call Amendment 148 in the name of Brian Whittle, already debated with Amendment 123. Brian Whittle, to move or not move?
Not moved.
The question is that Section 45 be agreed to. Are we all agreed?
Yes.
I call Amendments 61, 62 and 63, all in the names of the Minister and all previously debated with Amendment 1. I invite the Minister to move Amendments 61 to 63 en bloc. Does any member object to a single question? Oh, sorry, can you move the amendments, Minister? Moved. Does any member object to a single question being put on Amendments 61 to 63? No. Yes. Therefore, we will vote on the amendments separately. So the question is that Amendment 61 be agreed to. Are we all agreed? Yes. No. Committee is not agreed, therefore we'll have a vote. Those in favour of Amendment 61? Those against? Abstentions? Eight committee members voted in favour of Amendment 61. There were no votes against. There were 2 abstentions, and therefore the amendment is agreed to.
62.
The question is that Amendment 62 be agreed to. Are we all agreed?
Yes.
The question is that Amendment 63 is agreed to. Are we all agreed?
Yes.
I call Amendment 149 in the name of Jackie Bailey, already debated with Amendment 100, and I note that Miss Bailey is not in the room. Does any member wish to move that amendment? I call Amendment 150 in the name of Carol Mochan, already debated with Amendment 100. Carol Mochan, to move or not move?
Not moved.
I call on Amendment 151 in the name of Carol Mochan, already debated with Amendment 100. Carol Mochan, to move or not move?
Not moved.
I call on Amendment 64 in the name of the Minister, already debated with Amendment 45. Minister, to move formally.
Moved.
The question is that Amendment 64 be agreed to. Are we all agreed?
Yes.
I call Amendment 152 in the name of Paul Sweeney, already debated with Amendment 128. Paul Sweeney, to move or not move?
Move, Convener.
Moved. The question is that Amendment 152 be agreed to. Are we all agreed?
No.
Committee's not agreed, so we'll move to a vote. Those in favour of Amendment 152, please indicate. Those against? Abstentions? Thank you. 4 members voted in favour of Amendment 152, 5 against. There were no abstentions, therefore the amendment is not agreed. Call Amendment 153 in the name of Paul Sweeney, already debated, with Amendment 128. Paul Sweeney to move or not move?
Move, Convener.
The question is that Amendment 153 be agreed to. Are we all agreed? No. Committee's not agreed, so we'll move to a vote. Those in favour of Amendment 153, please indicate. Those against? Abstentions? Five members voted in favour of Amendment 153 and 5 members voted against the amendment. There were no abstentions. As there's a tie, I must exercise a casting vote, and my casting vote is against the amendment. Therefore, the amendment is not agreed. I call on, excuse me, I call on Amendment 154 in the name of Sandesh Gohani, already debated with Amendment 142. Sandesh Gohani, to move or not move?
To not move, given I withdrew 1.
Thank you. I call Amendment 65 in the name of the Minister, already debated with Amendment 1. Minister to move formally.
Moved.
The question is that Amendment 65 be agreed to. Are we all agreed? I call Amendment 66 in the name of the Minister, already debated with Amendment 1. Minister to move formally.
Moved.
The question is that Amendment 66 be agreed to. Are we all agreed? Yes. Call Amendment 155 in the name of Brian Whittle, already debated with Amendment 123. Brian Whittle to move or not move?
Moved.
Not moved. The question is that Section 46 be agreed to. Are we all agreed? Yes. Call Amendment 156 in the name of Brian Whittle, already debated with Amendment 123. Brian Whittle to move or not move?
Not moved.
The question is that Section 47 be agreed to. Are we all agreed? Yes. Call Amendment 157 in the name of Brian Whittle, already debated with Amendment 143. Brian Whittle to move or not move?
Moved.
The question is that Amendment 157 be agreed to. Are we all agreed? Committee's not agreed, so we'll move to a vote. Those in favour of Amendment 157? Those against? Abstentions? Four members voted in favour of Amendment 157, 6 against. There were no abstentions and the amendment is not agreed. I call Amendment 40 in the name of Alex Cole-Hamilton, already debated with Amendment 1. I remind members that Amendments 40, 158 and 67 are direct alternatives. That is, they can all be moved and decided on. The text of the bill is whichever the last agreed to will appear in the bill. Sorry, I'll repeat that. The text of whichever is the last agreed to, and that's what will appear in the bill. Alex Cole-Hamilton to move or not move?
Good morning, Convener. Good morning, everybody. I'd like to move Amendment 40, please.
Sorry, could you say that again, Mr. Cole-Hamilton?
I'm sorry, sorry, convener. Good morning, everyone. I move Amendment 40.
Thank you. The question is that Amendment 40 be agreed to. Are we all agreed? No. Committee is not agreed, and therefore we'll move to a vote. Those in favour of Amendment 40? Those against? Abstentions? Two committee members voted in favour of Amendment 40, 8 voted against, there were no abstentions, therefore the amendment is not agreed. I call Amendment 158 in the name of Brian Whittle, already debated with Amendment 1. Brian Whittle, to move or not move?
Moved.
The question is that Amendment 158 be agreed to. Are we all agreed? No. Committee is not agreed, so we will move to a vote. Those in favour of Amendment 158? Those against? Abstentions? Four members voted in favour of Amendment 158, 6 voted against, there were no abstentions, and therefore the amendment is not agreed to. I call Amendment 67 in the name of the Minister, already debated with Amendment 1. Minister, to move formally.
Moved.
The question is that Amendment 67 be agreed to. Are we all agreed? Yes. Committee is not agreed. We'll move to a vote. Those in favour of Amendment 67? Those against? Abstentions? Yes, your vote was recorded. Eight members voted in favour of Amendment 67, 2 against. There were no abstentions, therefore the amendment was agreed. I call Amendment 159 in the name of Brian Whittle, already debated with Amendment 123. Brian Whittle, to move or not moved?
Not moved.
The question is that Section 48 be agreed to. Are we all agreed? Yes. I call Amendment 68 in the name of the Minister, already debated with Amendment 1. Minister, to move formally.
Moved.
The question is that Amendment 68 be agreed to. Are we all agreed? Yes. The question is that the long title be agreed to. Are we all agreed? And that ends stage 2 consideration of the bill. I'm going to briefly suspend the meeting to allow witnesses to change places. Our third item today is consideration of an affirmative instrument, the Community Care, Personal Care and Nursing Care Scotland Amendment Regulations 2025. The purpose of the instrument is to increase the value of payments for free personal care and nursing care by 2.37%. The Delegated Powers and Law Reform Committee considered this instrument at its meeting on the 4th of February 2025 and made no recommendations in relation to this instrument. We will have an evidence session with the Minister for Social Care, Mental Wellbeing and Sport and supporting officials on the instrument. Once we have had all our questions answered, we will proceed to a formal debate on the motion. And I welcome to the committee Marie Todd, Minister for Social Care, Mental Wellbeing and Sport, Geraldine Campbell, Unit Head for Adult Social Care, Charging, Care at Home and Dementia, and Alice Hall, Deputy Director for Adult Social Care, Local Improvement and Transformation, both from Scottish Government. And I invite the Minister to make a brief opening statement.
Convener, thank you for the opportunity to speak to the committee today regarding a proposed amendment to the Community Care, Personal Care and Nursing Care Scotland Regulations 2002. The draft regulations before the committee today make routine annual increases to the rates for free personal and nursing care. These payments help cover the cost of those services for self-funding adults in residential care. This year we're proposing to apply an uplift based on the GDP deflator, which has been used historically as the inflationary measure to increase these rates. It will mean the weekly payment rates for personal care for self-funders will rise from £248.70 to £254.60, and the nursing care component will rise from £111.90 to £114.55. The most recent official statistics show that over 11,000 self-funding residents aged 18 and above receive free personal and nursing care payments in 23-24. They should all benefit from these changes. Convener, I'm happy to take any questions from the committee.
Sanders Gohani.
Thank you. A declaration of interest as a practising NHS GP. Minister, I have a couple of questions about this. So a GDP deflator was used as the measure, and I know that that has been used previously. And I also know the Scottish Government put more money in previously than the GDP deflator said was owed. My question around the 2.37% is, does the Minister feel that that is an appropriate uplift, or an uplift which will actually be the amount that is required as an uplift for the personal care to continue in the way that it is? And also, whilst GDP deflator has been used previously, I would also like to ask why we are using the GDP deflator as opposed to other economic measures.
So the member is absolutely correct. The GDP deflator has been used in previous years, so from 2011 to 2015. It was used. Then we had a number of years where the rates remained static. Then we went back to the GDP deflator. Over the last few years, during the pandemic, there's been above deflator, GDP deflator increases. So 21-22, an increase of 7.5%, 22 to 23, an increase of 10%, and 23 to 24, an increase of 9.5%. In 24 and 25, we went back to the GDP deflator increase, which in that year was 6.68. We have used this measure historically to uplift as the benchmark for uplift, and we're very pleased that we've been able to allocate additional resources to fund free personal and nursing care. The member will understand that we are operating in an extremely challenging financial context, so whilst it would have, there is no doubt I would have preferred to increase it beyond that, it is just not possible this year.
Sorry, Minister, can I just go back to my second question? Why is it we are using, or the government is using, a GDP deflator as opposed to any other economic measure?
Well, we have always either used the GDP deflator or used the GDP deflator to calculate an above inflation rise. So we've used it either just it itself, or we have used it to calculate an increased rate over the number of years that we have done this. The reason that we are not having an above inflation rise this year is because of the challenging financial context in which we are operating. In that context, I am pleased that we are able to raise this in line with the GDP deflator. We are able to make an increase which will benefit all of those people who are accessing personal care and social care and paying for it themselves.
Thank you. No other member has indicated that they wish to ask a question, so we will move to agenda item 4, which is the formal debate on the instrument on which we've just taken evidence. Can I remind the committee that officials may not speak in the debate? Minister, can I ask you to move and speak to motion S6M 16242?
I move motion S6M 16242 that the Health and Social Care and Sport Committee recommends that the Community Care, Personal Care and Nursing Care Scotland Amendment Regulations 2025 be approved.
Thank you, Minister. No member has indicated. Oh, Sanders Gohani wishes to speak.
Thank you. So just, I just would like further clarification as to why we are using the GDP deflator. And I know it's been used historically, but just to know why that particular measure has been used as opposed to any other measure. I did put this to the Minister twice, but it wasn't clear what the actual reason for using a GDP deflator as opposed to any other economic outcome measure would be. And historically, whilst, yes, I agree it has been used, I suppose the question still stands as to why.
Thank you, Sanders Gohani. Brian Whittle.
Thank you. I think further to that, I think, you know, obviously we will support increase in care payments. I think that I think there's a valid concern that over the long-term sustainability of these types of increases, especially if the underlying financial pressures on the care system are not addressed. So I kind of have the same concerns as my colleague Sanders Gohani here around why we use this particular method of making sure that these increases. So, you know, yes, I think there's conditional support, but I think as we go forward, I definitely would like to understand how we make the long-term sustainability is made.
Minister, can I ask you to sum up?
So the GDP deflator has historically been used to increase the FPNC payments annually, and the GDP deflator is a measure of general inflation in the domestic economy. Inflationary increases were made, as I stated in response to your earlier question, Dr. Gohani, from 2011 to 2015. They remained static for 2016-17 due to forecasts of inflation rates being too high, and ministers agreed to keep to that rate for the years 17-18. There was a return to inflationary rises. Evidence in recent years, I agree, has shown that the cost of providing FPNC has increased significantly and the rate hadn't kept pace with this. So to address that for 3 years, above inflation, so above GDP deflator, increases were made to rates on the basis of balancing affordability and taking into account the rising cost of care home placements. There was a return to inflationary rises last year, so again last year and this year I propose we use the GDP deflator. I hope that answers those people's questions. We are proposing an inflationary rise for next year, largely due to the balance between budget constraints and the wish to raise this at all.
Thank you, Minister. The question is that motion S6M 16242 be approved. Are we all agreed?
Yes.
Thank you. And that concludes consideration of the instrument. At our meeting next week, we will hold an evidence session with Sport Scotland, and that concludes the public part of our meeting today.